Moving on to Pregnancy Discrimination Act. In federal law, we have the Pregnancy Discrimination Act, which is part of Title VII. It's a type of sex harassment, gender harassment, gender discrimination. Under federal pregnancy discrimination, an employer is automatically required to provide the same accommodations to pregnant workers as to disabled workers with the same work limitations. Actually, this is false because last month in Young versus UPS, the Supreme Court said they're not automatically required to be given the same accommodation as someone who's disabled, but if they're not given the same accommodation, there has to be a legitimate business reason for that distinction, why the two people are being treated differently. The U.S. Supreme Court last month determined that this automatic right does not exist, but made clear that employers may treat pregnant workers differently only if there is a legitimate reason for the different treatment. So in Young versus UPS, we have a pregnant woman who has a lifting restriction from her doctor. She can only lift up to 20 pounds. The job requires lifting 70 pounds. UPS has a policy of automatically providing an accommodation, a light-duty accommodation, to 3 categories of people who are not able to meet the 70-pound lifting restriction. And those are people who are disabled under the Americans with Disabilities Act. They're limited in their major life functions. Number 2, those who have suffered on-the-job injuries. And number 3, people who have lost their certification under Department of Transportation requirements. Other than that, there's no specific policy. And so it's the accommodation, the light duty, is provided to employees who are not in those 3 categories on a case-by-case basis. So the pregnant plaintiff here, the formerly pregnant plaintiff, I'm sure by the time she gets to the Supreme Court, says, well, under the Pregnancy Discrimination Act, I was not treated fairly because I should have been treated the same way as anyone who is entitled to accommodation as a disabled person. The Supreme Court says, no, you're not automatically required to the same treatment. However, they remanded to the circuit court and said, we agree with you that they're not automatically entitled to this accommodation, but we need to send it back to you because we need to send it back down because we need a complete analysis of whether there is a distinction based on pregnancy between the way this worker was treated and the way other workers with similar limitations have been treated. So they look at whether similarly situated people are being treated the same, which is a theme you've heard before, or the plaintiff would have to prove that she was not provided with this accommodation because of discriminatory motives based on her pregnancy, which is a type of sex discrimination. Now, as you know, in Massachusetts, we have Mass General Laws Chapter 151B, under which pregnancy discrimination is a type of sex discrimination. This is a federal case looking at the ADA and looking at Title VII rights. However, there's good and important guidance here, which is, again, a reminder to employers that you want to look at these choices in the context of all similarly situated employees. If someone is similar in terms of their ability or inability to do their job and is requiring an accommodation in the way of light duty in this case, do you provide that to all employees? Do you provide that to some employees? If you're not providing it to all employees who have that same restriction, we want to look very carefully to make sure that there might not down the road be an inference because of the facts that it's the pregnant person who didn't get the accommodation, or it's the woman who didn't get the accommodation, or any other minority classification that, based on looking at all similarly situated people, the plaintiff can show was singled out and treated less favorably. Any questions on that? Okay. By the way, under federal law, discrimination against someone because they're A caregiver of a child or an elderly family member is also considered sex discrimination. If, for example, and this would be the same in Massachusetts, under Massachusetts law, you have a man who has, say, a 4-month-old baby and a woman who has a 4-month-old baby, and there are certain presumptions or stereotypes that the employer employs in making a decision to treat the female employee less favorably than the male employee, because they think, well, you know, the woman is the mom, the woman is going to give the caretaker, the woman can't do the same job as the man who has the same age child. So moving on, after pregnancy, we go to nursing moms in the workplace. All employers are required to provide nursing mothers with reasonable break time and a private room or other comfortable location to express milk for 1 year following childbirth. Is that true? Is that false? Okay. It is false because under the Fair Labor Standards Act, which many of you know is a federal law, employers with 50 or more employees are automatically subject to these requirements. They have to provide reasonable break time. They have to provide a private place that's out of view, that will not be subject to interruption by any other employee. And by the way, automatically the place cannot be a bathroom, no matter how nice the bathroom is. But employers with fewer than 50 employees are subject to these requirements only when compliance does not impose an undue hardship. So 50 or more, you have to do it regardless of how difficult and complicated it is for your operations. Less than 50, fewer than 50, you don't have to do it if it's an undue hardship. However, these obligations extend, interestingly, only to non-exempt workers. So if you have someone who's an exempt worker, who's an administrative or executive or professional worker, you're not required to provide these breaks. I think there's an assumption that someone who has that level of authority and in that kind of an exempt position is going to be able to take the time that they need to provide the breast milk for their child.